great. Thank you so much, Kelly, and glad to be here. My name is Ian Mitchell. I've been practicing with Pollart Miller for the last 15 years. I've been practicing in Colorado for 18 years. Currently, we operate in Arizona, Colorado, and Utah, and Nebraska as well. I always forget that one. I practice exclusively in civil litigation, almost entirely in insurance defense, both property claims, bodily injury claims, and bad faith claims. And we do a pretty large employment law section over here as well. But without further ado, we'll just kind of get started today in terms of bad faith claims. See if I can get all the technology to work well for everyone here. There we go. If anybody has any questions as we go along today, I think you can pop them up in the chat and I will check that periodically. Oh, there it is. I was going to say my chat screen disappeared. But for the most part, we're going to look at a couple of aspects today of bad faith. We're going to look first at what the issue associated with bad faith is and kind of how the law interprets it. And then we're going to talk about how, as adjusters, kind of things that I have found in my practice in defending these claims that cause problems, especially with regards to claim notes and commentary. And so that's going to be the focus of today. All right. So bad faith, ultimately, we're talking somewhat first party versus third party claims. And the easiest way to recall this or think about this, first party cases are going to be those cases where the insured has a direct contract with the insurer or has an assigned claim so that it's a direct contract with the insurer. Third party cases generally have to do with situations involving a third-party tortfeasor, and again, an assigned claim. You'll hear these in Colorado called basher agreements. Ultimately, the claims that can be brought are those claims of breach of contract, of bad faith tort, or in certain states, unfair and deceptive claims practices, which are statutory claims which carry multiplier penalties and have specific limitations on what insurers can and can't do. All right, so mostly we like to focus on first party bad faith claims. We're talking about direct coverage where the insured brings an action against the insurer. There's a denial of a valid claim, constitutes bad faith. The insurer is acting unreasonably, knows that its conduct is unreasonable and or recklessly disregards the fact that the conduct is unreasonable. And Travelers Insurance Company versus Savio kind of set that bar in 1985 in Colorado, but for the most part, at least across the states we practice, as well as in Wyoming, that is the standard. And it's basically a two-part test. The insurer acted unreasonably, and we'll talk about what some of those actions are here a little bit, and that they had knowledge that their actions were unreasonable, or they just didn't take the time and recklessly disregarded the fact that their actions were unreasonable. And it's really those two issues, the unreasonable determination of the action and what the insurer knew or should have known when they made that determination, that a jury is going to determine whether there's liability or not. We're going to do a quick poll question to make sure everyone's paying attention, and you'll see a poll issue pop up. And for those of you just popping on, if you need to go ahead and click the answer to the poll question, that'd be great. And I think that's everyone because Kelly and I are answering this question. So the question of bad faith claim can be proven even if the insurer did not have knowledge that its actions were unreasonable and followed proven industry standards. That's true. A bad faith claim can still be proven even if the insurer did not have knowledge and its actions were unreasonable and followed proven industry standards. So somewhat of an exception does apply in Wyoming specifically that we'll discuss. But ultimately, that is the standard. All right. So what does the plaintiff have to do? To recover in these types of cases, the plaintiff has to prove that there's basically an absence of a reasonable basis for a denial of policy benefits and that they had knowledge that they lacked that reasonable basis. Now, you'll hear me talk a little bit today about the fair debatability of a claim. It used to be that the fair debatability of a claim meant that there was some question, that there was some debate. That the plaintiff thought that they had more benefits available to them or were entitled to more benefits, but the insurer or the adjuster at the time said there was either an exclusion or that they haven't provided enough proof of their damages to provide that level of benefits. And if there was a fair debate, a lot of these cases were dismissed on summary judgment. That standard, however, pretty much nationwide has been reduced. The fair debatability argument no longer simply protects insurers or adjusters from these types of claims kind of from the starting of the complaint to the end of discovery. More courts are allowing these types of allegations to go forward to a jury because the fair debatability now has become more of a fact question as opposed to a question of law. All right, so what does it mean to act unreasonably? In the law, the simplest definition is basically negligence. Fail to do an act that a reasonable person in the exact same situation would or would not do. Now, for bad faith, we have the second requirement that you knew or should have known that your action was unreasonable. In Arizona, they call it an evil mind, right? There has to be an intentional element. Bad faith is generally considered an intentional tort, that you intended to cause harm to the insured. And what a lot of plaintiffs' attorneys will do, they'll attempt to take a broad kind of swath of cases to say, these denials are consistent across the board without looking at facts or without doing an investigation. There's more than one of them, and showing that prior cases have been treated a certain way provides evidence of the fact that they had an evil intent in this case. Now, what creates a problem legally is that this opens up a lot of discovery and can open up claims decisions from individual adjusters to insurers as to their pattern and practice over a 5-year, 10-year, 20-year period. And when you're talking about pulling case files over the last 10 to 15 years to defend the decisions made in a single case, some of these pattern and practice claims can drive up the cost of litigation more than the actual cost of the file. More useful definition I find is if a party fails to act in conformity with an industry standard of care, knows it, or disregards it. All insurance carriers have protocols, procedures in place. They have their own standards for certain making decisions. In general, those standards are going to match up with other insurance carriers, other TPAs, other adjusters, and you can see that it becomes an industry standard, a situation where similar decisions are made across the industry for the same reason. That will generally protect any decision that's made on a claim. However, in the 1950s, 1960s, and 1970s, some of those industry standards of care were found to be in and of themselves improper. And that's when we started to see a lot of changes in state legislatures, a lot of laws passed about statutory causes of action because the state stepped in, the legislature stepped in and wanted to kind of raise those industry standards of care and not have the industry just regulate itself. All right, let's talk about the first case study here, Fisher versus State Farm Mutual Automobile Insurance Company. And I don't really have the background of everybody that's attending today. So if this is just repetitive and boring, certainly speak up. I can make it more exciting, I'm sure. But I think everyone at this point has heard of Fisher, but I don't think everybody really understands kind of how it arose and what the issues were. What the Colorado Supreme Court ultimately found was that the insurance carrier was not required to tender the amount of a settlement offer rejected by an insured in order to avoid liability for unreasonably denying a payment. And more plaintiffs' attorneys are kind of sending out these settlement demands with time limitations in order to try and avoid this finding by the Supreme Court, saying that their settlement demand represented an undisputed amount, or a settlement offer represented an undisputed amount, and therefore they should be caught under Fisher. That, for the most part, has been caught by the trial courts recently and is not going forward, but it is a consistent push by the plaintiff's bar to kind of get rid of this first issue. The facts in Fisher, let me just back up a little bit. It was a UIM claim. Tortfeasor had $25,000 in a policy limit. The UIM coverage was $400,000. And when the plaintiff opened their claim and submitted their claim to the UIM carrier, they submitted $1.5 million in damages. State Farm approved the settlement with the $25,000 policy limit in December of 2010. 3 months later, in February of 2011, State Farm offered $59,000 to settle the claim. And in July of 2011, so just 5 months later, the plaintiff sued. Now, the plaintiff sued for obviously breach of contract, tort of bad faith, but their argument essentially was that the $59,000 settlement offer was an undisputed amount. And it was all based on the medical records of that $59,000. Now, when the court came out and said that the rejected settlement offer itself was not a basis for an unreasonably denying payment, they still permitted it to go to the jury to allow the jury to determine whether that amount of the settlement offer was essentially an undisputed amount. It just kind of eliminated the offer and the demand section of what had happened between December and February and just said what was undisputed at the time that the decision was made. The second issue, the insured could bring a claim before an amount of compensatory damages owed by the tortfeasor was determined. In the past, the amount of damages that the tortfeasor owed was required, and some of the old insurance policies still contain this language. That was found to be against public policy. Essentially, the court wanted to say if there's undisputed benefits, neither the plaintiff nor the insurance carrier has any reason to dispute them or that they were caused by that accident, then those amounts are supposed to be paid. The court did say that the insured could be liable for unreasonably denying the payment of the claim that was fairly debatable at the time. Now, this is where we started to see the kind of crumbling of the fairly debatable defense. As I said earlier, once that defense was brought up, you could show that it was debatable, you could win on summary judgment. You didn't have to go to trial. These issues didn't get put in front of a jury. That has just not occurred, and it seems to be a common practice across both Arizona, Wyoming, Colorado, and Utah to permit jurors to make the decisions as to whether something is fairly debatable rather than an issue of law. The fourth issue found in Fisher that the insurer was not obligated to not unreasonably delay or deny payment of the insured's medical expenses, even if other components of the complaint were subject to reasonable dispute. And this is where we have the Fisher payments kind of coming in. Once it's undisputed, Fisher basically held that that money has to be sent out. It can't be withheld for any reason because it's a detriment to the policyholder. And then finally, as the court found, that evidence supported the conclusion that the insurer unreasonably delayed payment of medical expenses. So obviously when State Farm made the initial settlement offer of $59,000, they had made the determination that that was a fair and reasonable amount to resolve the claim. What Fisher changed is that no, once the jury determines the amount that was not in dispute, those payments have to be made. Now, again, medical expenses or causation is not a question. Those are going to have to be sent out under UM/UIM claim. Same holds true for property claims. If there's a certain amount, the fire losses in Grand Lake, I know, under the CAT claims, there were quite a bit of initial payments for personal property at the 50% policy limits based on, the initial investigation. And then they permit the insureds to put in additional personal property loss statements to then address the remainder of the benefits under the policy. But this kind of the evidence supporting the conclusion that they unreasonably delayed the payment of those undisputed amounts, that's what's pushing the current claims. That's what's pushing the current cases. The next one I want to talk about is Scottsdale Insurance versus Tolliver. This is a 10th Circuit federal court case. And the reason I bring this up is because the intentional aspect of both the tort of bad faith, as well as the intentional aspects of the claimants or the insureds, was kind of brought into kind of a more clear stance that intentional conduct has to be proven by clear and convincing standards. Normally, we talk about more probable than not, or a simple over 51% for liability. If you think the insured committed an act, and you think it was bad faith, 51% bad, 49% they were okay, was sufficient in certain circumstances to prove bad faith. But in order to get punitive damages, or in some states like Arizona, to even get to the claim of bad faith, the intentional aspect of that has to be done at a higher standard. And really, in the manner in which we form the juries of the standard is through jury instructions, demonstrating that it's not just more probable than not, demonstrating that there has to be clear and convincing standard. And this standard has been successful in defending most cases on summary judgment if you have the facts. And it's not as high of a burden as no reasonable doubt that we have in criminal. But it is a way to address the claimant's claims that there was an intentional act by the insurance carrier to harm the plaintiff. It's certainly successful in Arizona. It's still more often a jury question in Colorado. The courts are less likely to take that on. All right, the last, I keep doing that. The last case study that I wanted to talk about today was Hatch versus State Farm Fire. Now, Hatch was a situation where, again, we're talking about the honesty of the actions taken. Wyoming uses a different term instead of knowledge of the recklessness or knowledge that they're acting unreasonably. They like to use the terminology of acting on a decision honestly and being informed about the decision. And the Hatch case was certainly interesting because they did present and were successful on their fairly debatable defense of the claim. However, in Hatch, they found that the investigation of the fire loss was ultimately so oppressive and so intimidating based on the statements made by the adjuster, by the fire investigator to the insured, those actions in and themselves could constitute oppressive or intimidating claim practices and could give rise to liability. And that is really, that is just kind of a type of understanding that even if you have an excellent case to deny benefits, the actions, the commentary in your claims notes can still give rise to bad faith. All right. I occasionally get a question as to, well, could this be bad faith? Is this a decision that generates bad faith claims? This is just a partial list, right, of actions that are taken either by the adjuster or the insurer that have given rise to this type of liability. Investigating a claim, delaying a payment, forcing an insured to litigate, arbitrate, engaging in trickery or deceptions, deliberately misinterpreting records or policy provisions for the purposes of defeating coverage, using threats of dire consequences to force the insured to agree to an unfair settlement, which also includes continuing their coverage or canceling their coverage, falsely accusing the insured of an arson and defending that type of a casualty claim, exploiting the insured's vulnerable financial position following a loss covered by the policy, making oppressive demands or imposing burdensome requirements not contained in the insurance policy, conditioning payment of the undisputed portion of the claim on settlement of the disputed portion, abusing the arbitration process, retaliating against the insured for filing a claim in the first instance and canceling their policy, abusing the insured subrogation rights. If you make a claim against an at-fault third party under UMUIM to recover amounts that you're expecting to pay, if you infringe on those rights of the insured, you can be called for bad faith. Unfairly imposing a premium increase, spoliation of any evidence, post-claim underwriting, unwarranted offsets, failure to inform the insured of remedial rights. Although I will preference that there are cases out there that say in first-party claims, you are required to notify them of the statute of limitations for bad faith claims. You're generally not required to do so in third-party context. And you can avoid that issue in some cases when they're represented by counsel. But if you incorrectly tell them what the statute of limitations is to bring their claim and they miss it, that can give rise to bad faith as well. So it's always best to kind of defer that question to the insured to tell them that they need to obtain legal counsel for any kind of legal advice that they're asking you for on things like statute of limitations. Here we go. All right. Poll question 2. True or false? The burden of proof for punitive damages is generally higher than regular negligence.
Hold on, I'm having a hard time getting that poll question to come up, Ian. I'm sorry, 1 second.
No, that's okay. I'm kind of looking off to my other screen to make sure that it pops up.
I just learned a new trick. It's up.
All right. I think that's everybody. All right. The answer is true. In most states, the burden of proof for punitive damages is generally higher than regular negligence or failure to act reasonably. And the same reason is for the same reasons we discussed in terms of the intentional tort. Punitive damages were created to basically punish the tortfeasor. And so if you're going to punish an insurance carrier for making a decision, the evidence, the level of evidence necessary in order to reach that punishment level is higher. It is at the clear and convincing standard as opposed to the more probable than not standard. Right. Okay, so this is the part that we're going to get to that is not the kind of boring law, right? So when pigs fly, this is really addressing the notes and communication log or your claims notes, any place that you write something down that gets saved in the file or type something in, whether it's in communications with your attorney, whether it's in communications with the insured, when it's typed down and saved, right? First thing I want to make sure everybody is aware of is that it doesn't matter what case you're in, it is entirely possible that a document that you believe to be protected, whether it be under the work product privilege, whether it be under the attorney-client communication privilege, whether it be under reserves, whether it be under your assessments, ultimately, anytime you write something down, you want to take the position that that is going to be seen by a jury, no matter what. Because although lots of those privileges do apply and attorneys are very adept at keeping some of that information out, it invariably something that someone thought that no one was ever going to see gets seen. Now, when pigs fly was a terminology that was utilized in bringing a case in Colorado. And during the course of the bad faith claim, during the course of the trial, when pigs fly was an expression that the insurance office constantly used by the claims representatives. They used it in communications with each other. They used it in their claims log notes. And it was really in reference to when a claim would be paid. Now, it was kind of an amusing tongue-in-cheek. It was addressed for cases that somebody, didn't believe the information that was coming in, or they thought was false, or, the exorbitant demands that we see, $1.5 million on what appears to be a $10,000 claim. What the plaintiff's attorney used, however, was multiple documents that had this term in it to argue to the jury that it was the prevalent attitude of the claims office to not pay claims or to delay the payments. The office itself actually had a stuffed animal with a pig with wings sitting in there. The plaintiff's attorney actually got a photograph of it, submitted it to the jury. They lost. It was an incredibly large verdict. And really the lesson is, any type of witty or funny statements or comments just don't have any place in correspondence, email, communication logs, especially when you're talking about the claim, talking about your evaluations of the claim, you're talking about the basis for your decisions. Anytime you're making any type of explanation, this is something that just can't be off the cuff. Anytime there is language in a claims note that is ambiguous, or it makes the adjuster sound like they may have some prejudice against the plaintiff or the insured, the plaintiff's attorney is going to put that on big block letters. They're going to post it up on a great big screen for the jury, and that's going to be their evidence that bad faith is being committed. And that's going to be their evidence that the intentional acts of the adjuster are what led to the denial. And they're going to ignore whether there's any actual fairly debatable reason as to why those benefits shouldn't be paid. And I'm just going to preface this again. Your computer, your insurance carrier's computer system, federal courts are very, very happy to order the disclosures of that information. So I really want to preface that it's so important. Anytime you type something down, you have to take into consideration that someone else is going to read it at some point. And you certainly don't want it to be unclear, joking, or in any way derogatory towards the insured or their claim. All right. You want to be prepared to explain to a jury under oath what is in the claims notes and what are in the communications. I always tell my adjusters, ask yourself, should this go in the claims notes? Conversations between an insured's employer when you're talking about wage loss claims and the claims representative. I have a case currently where the employer had a file on the employee that noted he had repeatedly faked injuries over the years in order to be drug seeking at the emergency room. Now, when you type that up in your claims notes, you want to get that factual information in there because it is going to be a specific basis for a denial of benefits. At the same time, you want to avoid opinion and commentary as to whether that makes the claimant greedy, money hungry, that they're lying, that they're committing fraud. Because as soon as you make that opinion or assessment, that assessment is going to be what a plaintiff's attorney is going to look at as the basis of the claim, as opposed to the underlying facts. Okay. So again, avoid disparaging comments or personal attacks. If you believe that there's fraud going on, what you do, instead of saying, I believe this is fraudulent, you say, the information provided by the insured or the claimant does not match the information we have, and you list it out. Very factual, and certainly you'll see in a lot of SIU departments kind of the check off the box requirements prior to sending them a file, and going along those protocols, setting up the facts that you're basing for meeting each one of those requirements. That's what needs to be in the claims notes. You want to be descriptive in your claims notes. The claims investigation is incredibly important, but the basis for an opinion of believing a claim is fraudulent can get the adjuster in trouble, because that is what the plaintiff's attorney is going to focus on during your deposition. So I'm sure everyone knows it's improper to consider a denial based to gain an advantage. Denials and investigations have to be based on the facts and the analysis of those facts, right? Comments that have given rise to liability in claims notes, and this can be one sentence in a 500-page claim note document. Starve him out, play hardball, use resources to force settlement. None of that commentary can ever be part of the assessment as to whether pay or deny benefits. They're certainly not appropriate for the claims notes. They're certainly not appropriate for the decision and consideration of whether to admit or deny benefits. You want to rely on facts. You want to rely on your experience and your evaluation as to whether a claim can be properly denied, what those facts are, how you came to that decision. You want to express it clearly, because again, if it's ambiguous, if it's not clear in your claims notes, when we're defending those claims, that's what we spend our time doing, as opposed to demonstrating that the claimant either doesn't have damages or that the insured doesn't have an actual basis for that property loss, or that the exclusion should apply. What we spend our time doing is defending ambiguous statements and claims notes that are basically the foundation for the plaintiff telling the jury a story to ignore the facts. And juries believe it. Even more and more as we see the television and crime shows coming on television, in the early 2000s, what we saw were, especially in criminal cases, people expected there to be more evidence, a very direct line between what they saw on CSI versus what they saw in the courtroom. And it takes a lot of education to provide to the jury that a lot of that is just make-believe. You can't find some of that evidence in real life. And We're having the same problem now in terms of bad faith, in terms of ideas that insurance carriers or adjusters are only out to deny claims. And it's that story that we have to defend against. All right, poll question number 3. True or false? An adjuster can utilize the information that the claimant is in dire financial situation and in need of a quick payment to justify offering less money to settle the claim in exchange for that quicker payment. Yeah. We give everybody just a minute or two to finish up voting. I think that's everybody. All right. Yeah, that's false, right? We just talked about that, and it's just a good reminder, one, that everyone's paying attention, because it's really my last poll question, although we have one more. But now that we get 100% of everybody answering that question correct, I feel like I've passed on a bit of information for everybody to enjoy. All right. This is the rule. No opinions, no emotions, or memorializing of value judgments of the insured should be made. You're looking at the facts, the basis of the decision only. After reviewing claim notes from multiple insurance carriers, third-party claims adjuster, what we find are a couple of things. Overly repetitive statements. I know there is a lot of copy and pasting during a claim as to basic facts or information. But when those facts change, or when there's discovery of new facts, or there's discovery of new information, that has to be the highlight when it comes in. I think adjusters frequently have somewhere between 200 and 300 claims on their desks. Being on top of the changes in the discovery of facts, or being on top of changes to information that comes in, can be incredibly important. And if it's just a matter of filling out the claims note on a 30-day calendar review, a fact or a change in a fact gets missed, that in and of itself can give rise to a bad faith claim. And that's what we're really trying to avoid. Each notation, each comment, each description about the evaluation of the claim is going to be reviewed by a jury. The more detailed and specific the claims notes are, that are providing a basis for the decisions that are made, make it easier for me to defend whatever that ultimate decision is. And again, I'm just going to highlight this again. Your emails between your defense counsel and yourself are generally privileged. That privilege can be waived. And for example, in Arizona, that privilege of attorney-client is waived quite often, because if the adjuster testifies during their deposition that they relied on information or knowledge that was shared by their attorney in making a decision to deny a certain benefit or deny part of the claim, then they've relied on that attorney's representations, and now the attorney, as the agent of the insurer, becomes on trial. And you start looking at what the actions of the underlying defense counsel did if this case was already in litigation. Litigation conduct can also be a basis for bad faith claims, even within the bad faith claim itself. So if I, as your attorney, am representing the adjuster and the insurance carrier in a bad faith claim, and I use overly aggressive discovery tactics, the complaint gets amended, and my actions are now part of the same bad faith case, at which point you usually have to get new counsel, and the costs of these cases can really explode. You know, in order to go ahead and protect those types of communications, you certainly want to clearly delineate when your communication is to or from counsel. In general, the mental impressions of a claims adjuster are protected, but in the bad faith action, they certainly can be required to be produced. All right, just some entries and some potential issues. Statements about coverage of a claim. You know, if there's any question that exists, whether benefits are owed due to an investigation that is incomplete, I'm sorry, or facts that remain in question. You know, statements like, it appears coverage will apply, or insured may be entitled to, but. If you haven't made a decision, it should say, we have not made a decision on coverage. We are missing essential facts or additional facts to make this determination. You don't want to prejudge a case in your claims notes. You don't want to say coverage will apply or appears it might apply, or you don't want to say in a claims note that you believe the insured may be entitled to certain medical benefits because you believe they're causally related. And then later have a doctor say that those aren't causally related because of additionally discovered facts, because this is going to raise those situations where you no longer have that defense of fairly debatable, because if you believed at the beginning of a claim that there was going to be coverage or an exclusion may not apply, they're going to hold you to that initial assessment regardless of what facts you have. You know, until the decision on paying or denying a benefit is made, you don't want to make suspected conclusions. This is the example we use: investigation initiated and determination on available benefits, if any, pending. And then you list the terms, including but not limited to what may or may not remain outstanding. We still have not received medical records. We still have not received medical bills. We still have not received the appraisal or the hail damage estimate. We still have not received documentation from the contractor. We still have whatever those things are. As specific as you can be, the easier my job is. All right, expertise versus experience. Frequently, adjusters have more expertise in handling this claim than the experts that we pay way more money to testify at trial. They've seen it before. They've seen 200 of these cases a month. They've been practicing for 20 years, but when they make commentary that is an expected expert opinion, they can certainly end up being in a situation where their decision without some underlying facts or without an expert opinion in hand can result in a plaintiff's attorney arguing that they prejudged the case without the facts, right? You want to avoid putting yourself in a position of being a fire investigation expert, an engineer, or an expert on the value, right? As a claims representative, as an adjuster, you probably have the knowledge. You want to convey that knowledge to the file, but you want to be careful about conclusory commentary without complete information. It can become detrimental. Good faith and fair dealing. You know, it requires the adjuster or the insurer to take information on the insured as equal on an equal footing as other evidence, which includes your experience, right? You have to give them a 50-50 shot when they're providing it. You know, statements made by an insured must be considered accurate when initially received, and it is the investigation that determines whether it's inaccurate or not. Any commentary when that information first comes in the claims notes that says, I don't believe the information this guy is sending me, we're going to send out a request, or we're going to send out somebody to do an investigation, or we're going to send out someone to get the value of this. That initial assessment and commentary is what gets their hook into a disputed question of fact, gets them beyond summary judgment, and gets them in front of a jury. All right. Insurers and adjusters have every right to investigate and verify the claims made by their insureds or a third-party claimant, but have to do so in a manner that includes the information provided by the insured, even if it's completely unbelievable, without immediately discounting such claims. I'm going to crush it. Finding facts and conclusions of law, commentary where the adjuster is taking on the role of a judge or jury in certain determinations. These can also give rise to these types of arguments. Credibility assessments and claims notes certainly can be in there in terms of whether you believe the claimant is credible or not, but it's the underlying issue of fact as to whether they're credible or not, right? Honesty of the insured in question, or the claimant appears to be holding something back in a recorded statement, is what the plaintiff's attorney is going to point to demonstrate that you did not provide them with the benefit of the doubt when they provided you the information. These arguments are becoming more and more prevalent to demonstrate that the adjuster is prejudiced against the insured prior to even a claim being made. A better entry when you think someone is not being forthright. Discrepancies and inconsistencies appear to exist in the history provided by the claimant. And then you describe what those discrepancies and inconsistencies are without making the credibility, the personal opinion credibility assessment on it. Okay. Little fact I like to add in here at the end, that in Colorado, if you're talking to an insured, you're talking to a contractor, you're talking to anybody, you should be aware that that phone call can be recorded by them and they don't have to tell you about it. Those recordings can become admissible evidence. So always keep that in mind anytime in Colorado is calling you on the phone. All right, we have a couple minutes left. That is the end of the presentation for everyone. I hope it provided everyone with a little bit of information there. Let's see here if I can get this to do what I want it to do.
Oh, I'm going to throw out that last poll question too while you're.
Oh, that's right. I need to get the last poll question in there.
The last one. See what everyone thinks about getting back in person next month for a little bit. Something social, something fun. Maybe not. Maybe we'll wait till the fall. What's everyone thinking out there? I'm with you, maybes. I'm with you. Looks like that's wrapped.
Vaccines and low numbers, I think. Vaccines and no low numbers.
Happy hours just aren't as happy as they used to be. So that is good to know. Definitely thank you for sharing your information, Ian, with us. This has been great. A lot of great information that you shared. So we appreciate that. And again, anybody who has Wyoming license numbers will get the credit. Crystal will follow up with you there.
And I'm just going to pop this up on the screen really fast for everybody to grab. If anybody wants a copy of this presentation, please let me know. There's nothing ground shaking or groundbreaking in it. Certainly not a how-to. But if you want one, please let me know. And I'm just going to share this real fast. There we go. Obviously, easiest way to contact me is by email. I've provided my direct phone number. If you have any questions or anything comes up or something pops in, I'm always happy to answer those types of questions at any time. All right. Hopefully that was fast enough. And obviously you can also get in touch with Kelly. She knows how to get in touch with me.
Definitely. Well, that pretty much wraps up our April meeting. I just want to remind you again that by the time we meet next month, we're going to be reviewing college scholarships. So if you're an active member and all it takes is paying membership fee, your kids are going to have some money coming to them for their next year of school. Please make sure they get that in by May 1st. Send them the link. It's on the website. There's a scholarship tab. You'll find the application you can get downloaded on your computer and edit from there. We look forward to having everyone back on Zoom Thursday, May 13th. Our topic will be announced in later emails coming out to remind you of the meeting. And please let us know if there's anything in the meantime that we can do to help you out here at the Property Claims Association.
Kelly, before you end, we do have a bunch of questions kind of popping in here. I just wanted to answer a couple of them if I could. Is that all right? Does everybody want to hang on for a couple minutes?
You've got it.
One of the questions, what terms are best to describe an insured or a claimant when they appear to be providing false information? When they're providing false information, it's not what you want to describe the claimant or the insured as, it's that you want to describe the discrepancy of the information. Claimant said X, the information we have is Y, we have verified the information as Y, or we are investigating Y through X, through whether it's surveillance, whether it's through sending out a fire investigation, whatever it is, that's how you describe it. You describe the information and why it's not credible or why it doesn't match with something else, as opposed to describing the claimant or the insured. What parts of an adjuster's claim notes or correspondence are protected from discovery and bad faith claim? That is a case-by-case basis. Again, if I can stress anything, it is that anytime you type something in and it is saved, someone's going to see it. Whether that's the judge making a determination as to whether it's protected or not, whether that's all the attorneys, or whether that's a jury, somebody is going to read it. And that's why it's so important to really take care as to what you're putting in those things. When does a bad faith claim accrue for the statute of limitation purposes? That is a really hard question and answer because it's factually based. Accrual is usually based on when the plaintiff who's suing knew or should have known that they suffered a damage. So that is the date of the denial. It can be if they believe that there's been a delay of a payment of benefit. As soon as that delay causes them a damage, it could accrue. That's a really tough one. And that is more of a fact-by-fact basis. But essentially, when a decision is made or a period of time has gone on to which the decision not being made has caused them a damage, is the date of accrual. That's the best I can do on that one. If an adjuster on file can be called to testify about decisions made on the file, even if they did not make the actual decisions to pay or deny, absolutely. Every person who touches the file can be called to testify about what they did, knew, or saw. And preparing adjusters for depositions is never a fun process. No adjuster wants to be deposed, but it's really important to work with the attorney, be prepared, go over questions, go over the decisions that you touched or the decisions you made or the investigation. And you want to have probably 1 or 2 prep sessions. If you're not having 1 or 2 prep sessions with your lawyer preparing for a deposition, call them and get prepared, because depositions can make or break the case. Are mistakes or clerical errors in adjusting file grounds for bad faith claim? It depends on how egregious the clerical mistake is. If it was clear that someone had a loss, if it was clear that they provided you evidence of that loss, and for some unknown clerical reason it didn't make it in the file, you didn't become aware of it, it can certainly demonstrate that you didn't act unreasonably with knowledge of your unreasonable action, right? That you didn't do it with reckless disregard. However, if lots of things go missing in lots of files over a course of time, that is going to be reckless disregard, and that is going to be bad faith. So again, the case-by-case basis a little bit, but general errors or mistakes are not going to have the intentional element for these types of torts, for these types of claims. But if it's an error or a clerical mistake that a jury just would not believe is a mistake, that's what they're going to rely on. All right. I think that's it. And I will, I hope everybody has a great day.
Thanks again, Ian, for all your time. We really appreciate it. I'm glad
Everybody
there
have
was
a good
some
one.
extra questions at the end. Wonderful. Well, have a great day, everyone. We'll see you again on the second Thursday of May. Take care and be safe.